My name is Jeff Morgan of Dallas, Texas, and I want to give a quick introduction to this video. The reason I think this video is important is because during COVID time, there was a background on legal standards, the public right to access to remote hearings during the COVID-19 pandemic. And this was written by Judge Roy Ferguson. Judge Roy Ferguson was the judge when the cat lawyer was on. A lot of people still remember the cat lawyer who couldn't change his face back to a normal lawyer face, so they called him the cat lawyer. Anyway, but this was something that Judge Roy Ferguson wrote with regard to the public's right to access remote hearings. And it says here on March 13, 2020, the Supreme Court of Texas and the Court of Criminal Appeals issued the first emergency order regarding the COVID-19 state of disaster and authorized all courts in Texas in any case, civil or criminal, without a participant's consent, to conduct any hearing or court proceeding remotely through teleconferencing, video conferencing, or other means, and to conduct proceedings away from the court's usual location with reasonable notice and access to the participants and the public. It's very important to note here that the public is allowed to access remote hearings. In our Texas Constitution, it says the court shall remain open. And that means as well, among other things, is that the public has access to the courts. The courts belong to we the people. We the people have the right to enter our courts and to monitor our judges' performance. We have a right to make sure that justice is being dispensed. We have a right to see that judges are actually doing the right thing. And we also have the privilege, the right, the obligation, the duty to report bad judges and things that we see that are not in accordance with justice. Attorneys talk about the thin black line. We must keep the trust in the thin black line. If we lose trust in the thin black line, our society will disintegrate. Well, the thin black line right now, the judicial branch, has lost the trust of the people. And evidence of that is if you go back to October the 2nd, 2024, just a few weeks ago, there were 97 people, I believe, that went down to complain to the State Commission on Judicial Conduct. This is the agency that is supposed to be in charge of monitoring judicial conduct, and they have a lot of failings, they have a lot of inefficiencies, there's a lot of complaints, a lot of people that were down. There are people that wanted to say, you are not doing your job, do your job. 45 people testified, and it seemed to me when watching the hearings, the biggest concern that the State Commission on Judicial Conduct had was, are you staying within your 3 minutes? If you went above your 3 minutes, it was time. Now, people drove them throughout the state, and I think that honestly, if you're going to be driving a couple hundred miles, you should have the right to speak for more than 3 minutes. I don't think that, we need to be up here with a stopwatch and just saying, well, your 3 minutes are up, that's it, we don't want to hear from you. And there's no feedback from the commission. The feedback did not say, we have listened to you, we've seen that there are a lot of issues with our courts, lots of complaints, lots of injustice, lots of trauma being caused by the judicial branch of our government, and we apologize to you for failing to uphold justice, uphold our duty to monitor the courts and to make sure that our judges are acting properly. The State Commission on Judicial Conduct has failed epically. And one of the ways that they failed is that they've made it harder, more difficult for the public to actually submit complaints. It used to be that you used to be able to go online and submit an online complaint. And evidently the State Commission on Judicial Conduct, maybe to polish their image, maybe to make the courts look better than what they really are, maybe to reduce the caseload that they had in front of them, they took that away. One of the principles of any company that wants to have transparency and honesty and integrity and things like that, you make it easier for people to report. Many companies have anonymous lines that you can call in if you see something. And as we say in Texas, if you see something, say something. With the State Commission on Judicial Conduct, they have a practice, evidently. If you see something, we're going to make it very hard for you to say something. We're going to put obstacles in your way. We're going to make it much more difficult so that maybe you're going to just get frustrated and say, oh, you know what, forget it. Let's let it go. And then we can say, well, they're doing such a great job. They're doing a terrible job right now, the State Commission on Judicial Conduct, and as a result of that, our courts are committing some very egregious offenses against judicial canons and against even our constitutional rights. And in this background of legal standards, the public right to access remote hearings during COVID-19, Judge Roy Ferguson was laying out the framework. And one of the things that he mentioned in here was that the public has an independent right from the litigants to observe the courts. well, something is embarrassing is going to take place, or the litigants don't want it to be public. Sorry, but the public has an independent right. And he also says at one spot too that if the court is closed to the public, to the people, that this could be a cause for the ruling to be reversed, even if it's for a portion of a voir dire or something like that. The reason I'm saying all of this is because a couple of weeks ago I was a court observer for Bradley Miller, and Bradley Miller was in court. I believe the judge's name was Judge Tillery, I believe it was. And during the course of that hearing, I got kicked out of the hearing 84 times. And the video to prove that is going to be following. It's going to be attached to what I'm saying right now. Not only did I get kicked out, but Rustin Wright got kicked out. Rustin Wright also was there as a court watcher for Bradley Miller. Not only did I and Rustin Wright get kicked out, Stuart McMullen got kicked out. And Stuart McMullen as well was a court watcher for Bradley Miller. And not only was I and Rustin Wright and Stuart McMullen kicked out, Robert Garza was kicked out. Robert Garza, another court watcher for Bradley Miller. Interestingly, nobody got kicked out who was not there to be a court watcher. We would get kicked out and come back in, kicked out, come back in, and none of the other people had this issue. It was only those people that were watching the court, watching to make sure that justice was being done in our courts for our friend Bradley Miller. And between all four of us, we probably, for me it was 84 violations that they did. For Rustin, I don't know how many it was in Stewart, but it would probably not be a big stretch to say that we're upwards of 120 to 150 times that we were kicked out. Violations, kicking the public out of the court. And when this is happening, when the public is not allowed to monitor their courts, to monitor their judges, these are called star chambers. Star chambers are where bad things happen. It's like, we want to make sure the public isn't watching this so that we can dispense injustice. And a lot of these courts dispense injustice. I know Bradley Miller, I followed a number of his hearings, and he has been the recipient of a lot of injustice. And so it was really, really shocking to see the blatant, the willful means by which they kept on trying to kick us out. And you'll see as you're watching this tape how many times this has been taking place. Now, part of the reason I'm also putting this out is because the State Commission on Judicial Conduct, that august body who heard all of the testimonies and wanted to make sure that you stay within your 3 minutes, and but they said nothing with regard to what they were going to do. This is blatant. This is blatant. You cannot refute this. So I am going to submit a complaint to the State Commission on Judicial Conduct. And being as they no longer take online complaints because they want to facilitate fraud or they want to stop the reporting of injustice, we have to actually write our complaints. Well, I'm going to publish this. I'm going to put it online. I will send them their complaint right now, even though we should be able to submit it online. And I'm going to invite you, the public, also to do the exact same thing. The court case will be referenced, the time and everything else. And I want you to take a look at what happened during this hearing. I think that if we had 100 people watching this video and half of us or a third of us wrote letters about the injustice that took place in this court, the clear violation of the open court doctrine, it would basically have to put the State Commission on Judicial Conduct on notice that we, the public, are watching them, and we, the public, want justice within our courts. And I would also say, too, to the media, if you see this, this is another egregious example. You might be shocked. I can't believe this is going on. This is happening almost every day in the state of Texas. And the violations are much worse than this, actually. Media, if you want to be a good media person and break a story, this is a story that needs to be broken. Because this is just one example out of hundreds, even thousands of examples. On October the 2nd, 2024, 45 people testified in front of this body about the injustices that they had suffered at the hands of either family court or probate court, occasionally criminal court. We cannot trust our judiciary, and we most certainly cannot trust the people that are over top of this. So anyway, I'm going to present to you the hearing. This is Judge Tillery, I believe it is. I will have information at the end, but just count. Well, you can count along with me, because every single time I got kicked out and I came back in, it's numbered. 84 times it took place. Anyway, I hope that you will join me in writing, complaining to the State Commission on Judicial Conduct. Let them know that this video is out there. please reference the video. Please let them know they are no longer going to be this body, this do-nothing body. And the reason I say that is I've written about half a dozen complaints down there, and they are a do-nothing body. I've talked with them, I've taken evidence to them, everything else. They are a do-nothing body. Every so often they act like they're really doing something, but if for the most part they are a do-nothing body. So anyway, I present the video to you. I hope that you also get involved with this. I know that probably I'll have at least 10, 12, 15 friends that will be involved in this audit right off the bat, but I'd love to see more and more of the public. And that was one thing that I wanted to say as well to all those people that were down there for the State Commission on Judicial Conduct hearings. It was so good to see you. I knew maybe half a dozen to a dozen of the people down there, but to see another 30 people that I have not met in the past, it was great. The message is getting out that you cannot trust the courts, you cannot trust the judges. You could make it very easy. Install cameras in every courtroom and let the public watch what's going on. After all, if it was good enough during COVID-19, why isn't it good enough right now? What do the judges have to hide other than their injustice? Anyway, that's it. Thanks so much.
Your Honor, I just as explanation, I had to give the legal background for federal removals to explain why Judge Plumlee has no immunity, which I'm going to get to now.
I was just asking how much longer, because we have other hearings, and this would allotted a particular amount of time. So it's okay. You told me, so you may proceed.
Thank you, Your Honor. So on the date of that November 2016 hearing and the July 31st, 2023 hearing, Defendant Plumlee was deprived of all jurisdiction. Now, the U.S. Supreme Court has stated that judges are deemed to be liable to civil actions, and that's a quote, for, quote, acts done by them in the clear absence of all jurisdiction over the subject matter. That's from Bradley v. Fisher, 80 U.S. 335 at 351 from 1871. Now, Bradley v. Fisher is also cited by Stump v. Sparkman, 435 U.S. 349 at 356, 357, and 360 from 1978. Further, and this is from Morales v. Waco, quote, a judge is not immune from liability for non-judicial actions not taken in the judge's official capacity, end quote. And, quote, a judge is not immune for actions, though judicial in nature, and that's a crucial point here, though judicial in nature, taken in the complete absence of all jurisdiction. That's Morales v. Waco, 502 U.S. 9, 1991 at 11 through 12. Again, that's a crucial point. It's clear that Plumlee's acts were, quote, judicial in nature because she was acting like a judge and signing a fake order. But Morales v. Waco also makes it clear that a judge has no immunity for such, quote, actions, though judicial in nature, taken in the complete absence of all jurisdiction, end quote. Now, Defendant Plumlee and Mr. Graydon, and of course Mr. Finley, would like you to ignore that Supreme Court ruling, but it is controlling. The distinction in the law couldn't be any more clear. A state judge acting during a federal removal is acting in the absence of all jurisdiction, is therefore not acting in her judicial tort. At the time of the signing of the purported orders on November 17, 2016, and July 3rd, over the subject matter and with, quote, usurped authority, end quote, thus, quote, no excuse is permissible, end quote. And I'm quoting Bradley v. Fisher, 351 through 2. Plumlee's assignment to the 330th Family Court Case number DF 13 during the time of this incident, which occurred during a federal removal. I want to make it absolutely clear. There's one single exception to judicial immunity, and it is a lack of jurisdiction. This is it. Mr. Graydon and the Texas 5th District jurisdiction, end quote, doesn't really mean jurisdiction. This assertion, quite simply, is a lie. It is judicial perjury. The only definition of jurisdiction that matters here is the one set forth in federal law and in the subsequent Supreme Court precedent I just cited. An errant state court opinion or two cannot overturn federal law. We have something called the supremacy clause. Moved to federal court, the state court and the state court judge lose all jurisdiction. Defendant Plumlee issued her order without jurisdiction. She lost all immunity by doing so, and she is thus liable for the act. Plumlee doesn't have sovereign immunity either. The Texas statutory or constitutional provisions are not prohibited by sovereign immunity, even if a declaration to that effect compels the payment of money, end quote. And that's City of El Paso at 372, 2009. Oh, sorry, Yar. That Heinrich ruling. The Heinrich ruling continues. A state official's, I'm quoting now, a state official's illegal or unauthorized actions are not acts of the state. Accordingly, an action to determine or protect a private party's rights against a state official who has acted without legal or statutory authority is not a suit against the state that sovereign immunity bars. And that's from Heinrich at 370. Defendant Plumlee violated several state and federal laws, which I've cited at the beginning of this argument, by signing these. An individual who acted outside the law, and she is liable for her actions. And because Plumlee's actions have caused me financial harm and injured my rights, I certainly have standing to bring suit. I've argued that Plumlee has no immunity under the Texas Tort Claims Act, and I'll leave that to my petition because it's fairly obvious. I'm not suing the state, so I'm suing an individual. So the Texas Tort Claims Act. Mr. Graydon, Mr. Graydon and Ms. Plumlee, Judge Plumlee, and Defendant Finley have cited a case of federal removals. 92 Southwest 2nd, 56 Texas Appellate, Houston. Citing the case in a deliberately misleading attempt to falsely redefine the meaning of a court's jurisdiction in the context of a federal removal. As Mr. Graydon notes, the Texas 5th District Court of Appeals regurgitated this spurious argument in one of my prior appeals, and that case is Miller v. Plumlee, number O-V 2022. And but again, what I want to make clear here is Bratt v. West involved the judge's action after a recusal motion had been filed, not a federal removal. Recusal motions are governed by Texas Rules of Civil Procedure, Rule 8. Jurisdiction either on the part of the judge or the court itself. By contrast, 28, quote, the state court shall proceed no further unless and until the case is remanded again, unquote, as I said. And this is backed up again by the extensive U.S. Supreme Court precedent I've cited. To be clear, federal removals and state court recusals are two completely different judicial scenarios with completely different government or judge jurisdiction, but a federal removal absolutely divests the state court and state judge of all jurisdiction over a case. Even the federal case, which Graydon and Plumlee cited, Hensel v. Gerstein, 608 Federal 2nd, 654, 5th Circuit, 1979. That case involved a judge who was in a different state, New York versus Florida, who proceeded with a criminal prosecution. The judge in that case was not. In addition, the Hensel opinion cites a Sixth Circuit case, Lucarell, which reaffirmed that, quote, a judge loses all immunity when he acts in absence of all jurisdiction. And Hensel also. And that's Hensel at 657 through 658. Which, of course, naturally accords with Morales v. Waco and Bradley v. Fisher. So they're kind of undermining their own argument because even the state and federal and just a quote from Bratt, quote, in determining whether the focus is on whether the judge had the jurisdiction necessary to perform the act of that kind in the case. See Morales v. Waco. And that's Bratt v. West at 68. And of course, Judge Plumlee did not have the necessary and 2023 purported orders because she had lost all jurisdiction during the federal removals. And in my response to Plumlee's plea to the jurisdiction, which I filed on September 26th, pages 12 through 17. So again, neither Bratt v. As I said, Mr. Graydon and Judge Plumlee are engaged in what is essentially creative lying, which of course, again, is a violation of the 14th Amendment guarantee of due process. Ninth Circuit case, Hardwick v. Vreeken, number 1517, which states that. Again, as Mr. Graydon said, he alleged that over my case, family court case. Well, that may be true, but Judge Plumlee had no continuing jurisdiction over the purported orders because they are not legitimate instruments of any court, and therefore not part of the 330 court case. As I've already argued, these so-called orders she signed in 2016. So appeal is not the only avenue of remedy. As the Texas Supreme Court and the U.S. Supreme Court have ruled, a void judgment can be collaterally attacked, quote, at any 5 Southwest 3rd 552 at 566 Texas Supreme Court 2012, and U.S. Supreme Court case Peralta v. Heights Medical Center Incorporated 485 U.S. 80 at 86 from 1988. That's part of what I'm doing in this. That's just one part of it. Again, I just, as I said, the supremacy clause controls and takes precedence over those two Texas 5th District Court of Appeals cases that both Mr. Graydon. And these two cases that they've cited are two of my prior appeals from state civil court. 21-00431-CV 2022. And Miller v. Diaz, number 05-21-00658, and that's Dallas, January 12, 2022. Now, even in that latter case, even the Texas 5th District Court of Appeals noted the 330th quote in that ruling. That's at page 11 of that ruling, which of course Judge Plumlee, Defendant Plumlee, and Defendant Finley did not mention. But Mr. Graydon mentions that the jurisdiction has the word jurisdiction has a different meaning in the context of judicial immunity, and thus Plumlee and Diaz had immunity for acts done during the pendency of a federal removal. But again, case to back up that bogus conclusion, because there isn't one. And those two 5th District Court of Appeals rulings are in direct conflict with the U.S. Supreme Court rulings in Bradley v. Fisher, Stump v. Sparkman, and Morales v. Waco. The Supremacy Clause, U.S. Constitution, Article 6, Clause 2, dictates that state law must follow federal rulings, which of course was affirmed in Hallett v. Rose, 496 U.S. 3. This quote, the Supremacy Clause forbids state courts to dissociate themselves from federal law because of disagreement with its content or refusal to recognize the superior authority of its source, end quote. That's Hallett v. Rose at 356. Interestingly, the Hallett ruling also appropriately contains the sentence, quote, the force of the Supremacy Clause is not so weak that it can be evaded by mere mention of the word jurisdiction, end quote. And that's Hallett at 382. Decide whether it's going to abide by federal law, 28 U.S. Code Section 1446, Bradley v. Fisher, Stump v. Sparkman, and Morales v. Waco, or ignore federal law, including U.S. errant, I believe intentionally errant, Texas 5th District Court of Appeals rulings. There's only one proper legal route here, and that is to recognize federal authority when it comes to judicial immunity. I've argued standing in my response. Plead of jurisdictions. I won't belabor that. I'll stand on my pleading there. I do want to emphasize that I'm not suing under a criminal statute in this suit. I cited criminal statute because I wanted to criminal acts, and also the commission of a crime deprives an attorney of immunity, which is relevant in this case. Just to briefly discuss, first of all, my Section 1983 claims are cognizable because, well, I want to clarify that I'm suing defendant Plumlee in her individual capacity. But even if the court were to construe the suit as one against Plumlee in her official capacity, it allows suits for declaratory judgment where, quote, declaratory relief was unavailable. I have clearly demonstrated relief regarding the void orders of 2016, 2018, and 2023 is not available. It is no court in the country, state or federal, will address this issue. Certainly, and just to bring this up, this very court dismissed my 2021 suit for declaratory judgment. Where the final issue I wanted to address is one of mental anguish. I want to assert that my claims of mental anguish are certainly cognizable. Mental anguish or emotional distress, however you want to term them, are secondary claims. The primary claims are negligence rights. And further, most importantly here, the Texas Supreme Court has ruled that the destruction of the parent-child relationship is inevitable. Moore v. Lillebo. Quote, then as now we wish, and it would be unrealistic to separate injury to the familial relationship from emotional injury. 1 Southwest 2nd at 5-3. When such emotional injuries are alleged, a plaintiff should be permitted to prove them, including Lillebo, 72 Southwest 2nd, 683 at 684, Texas Supreme Court, 1987. Resulted in the destruction of our parent-child relationship. And just as obviously has resulted in mental anguish. The Texas Supreme Court has also ruled that recovery is authorized. That case quickly is Cytex Funeral Services, Inc. v. Nelson, 540 Southwest 3rd, 539 at 544, Texas, 2018. Tyler v. Likes, 962 Southwest 2nd at 489 at 496. That's Texas, 1997. For years that she signed these void orders without jurisdiction and has refused to declare them void. And despite these multiple appeals which she's been served with and the last civil suit, such a position can only be the result of malice toward me. For mental anguish in cases of defamation, which I briefed under 3rd, 878 at 886, Texas, 2017. So it's very clear that my claims.
All right, thank you, sir. Mr. Gray?
Your Honor, I'll be very brief.
Listen, you get last words on your motion.
From this hearing while I'm speaking.
I don't know that you will, but who knows?
With respect lack of jurisdiction because of the ongoing 30th, that matter is resolved. It has been ruled. This court was correct then. The Court of Appeals affirmed this decision of this court. With respect to from the Second Court of Appeals, interest of AW, and no. In that case, Mr. Wright made the argument have its trial vacated and voided and the Court of Appeals agreed with him. This court similarly does not have decision-making. The orders that were entered, the enforcement of orders that were acknowledged and followed courts, the orders from a court that has continuing and exclusive jurisdiction, all of these things stem from the decision-making and enforcement or following of orders that were issued by the 330th Judicial District Court. This court simply does not have jurisdiction to entertain that are better situated in a different court and excludes this court's exercise of any jurisdiction. With respect to judicial immunity, Mr. Miller has made these arguments before. They have been rejected before, not once, but multiple times. There was, as we have identified in the reply brief to the plea to the jurisdiction, the suit involving Mr. of the context of absence of all jurisdiction as it applies to judicial immunity. Versus anything else. It is in the context of judicial immunity. What does that term mean? The court similarly, not the one that you had, but the other one of the other lawsuits that he filed, which we have quoted in the report. Incorrect, that he did not understand, and that in fact all of the actions that he has alleged qualify under judicial immunity. Mr. Miller is upset about this, and I am